currently working with the contract closure group at NCL. I am a dual qualified lawyer with expertise in both Indian and Canadian law, and I've dealt with various contracts. And this particular topic, that's the crucial provisions in vendor contracts, is quite close to my heart because I deal with these topics on day-to-day basis. These provisions can make or break a successful partnership and can have far-reaching complications. First of all, I would like to talk about what is subcontracting. So subcontracting is basically a contract where a part of the services are delegated to a subcontractor by a prime contractor on the basis of its contract with the end customer. Today, I'll be dealing with these provisions from the perspective of the prime contractor. Now, while reviewing the procurement contracts in the context of an end customer, several key provisions are crucial to consider. First of all, you need to see that the scope of work and deliverables are clearly defined. The quality, the quantity, the specifications, everything needs to be mentioned to the subcontractor. Secondly, the price and payment terms have to be determined and need to be back-to-back with the end customer. What do I mean by price and payment terms? To be put in short, you should get your payment from the end customer and only then pay your subcontractor. This would ensure commercial viability. Moreover, provisions like transition fee, late payments, and schedule of payments, due dates, etc. need to be considered. Another important aspect of subcontracting arrangements is the term and termination clause. The term and termination clause is extremely important. Your term with the end customer must not be shorter than your time commitment with the subcontractor. A prime contractor should always have termination clauses in place, such as post-termination and termination for convenience. Post-termination would primarily mean that if the end customer terminates the services, then the services of the subcontractor would no longer be required, and the prime contractor would have an immediate right of termination in this case. This is extremely important because a prime contractor would not like to pay for anything that has not been committed by the end customer. Secondly, termination for convenience is crucial because at times you would need that protection with your subcontractors as well. Secondly, it's also important to see what kind of termination clauses are agreed with the subcontractor and whether that would affect your deliverables with the end customer. In such cases, it should be seen that whether the subcontractor is replaceable or not, and what avenues you have in case it does terminate the agreement. Apart from that, warranties, guarantees, and insurance requirements are important. So is the confidentiality and data protection provisions. What kind of data is being dealt by the subcontractor and how it's dealt need to be clearly defined. Adequate protections that the end customer wants in these contracts must be clearly drafted. How the intellectual property right in the engagement would be handled, who would be owning it, how it would be licensed, everything needs to be taken care of. Moreover, certain compliances with laws and certain performance levels, service levels, credits, etc. need to be clearly adopted. Apart from that, legal provisions and risks have to be taken into account. So the limitations of liability and indemnities, unlimited liability exclusions need to be clearly understood, and these risks need to be clearly balanced between the subcontractor and the end customer. Indemnities are extremely important here because there can be a third-party claim against the prime contractor from the end customer, and if certain indemnities are not guaranteed in your contract with the subcontractor, you might be at risk. So all these needs to be balanced out. I do understand that in many circumstances, they will not be back to back. but these risks need to be clearly identified, and the business and procurement have to be uh, informed about these risks before getting into any kind of transaction. Apart from this, it's extremely important that the customer flow down terms are incorporated in your subcontracting agreement. What are customer flow down terms? Customer flow down terms are essentially certain provisions, obligations, and requirements that the end customer wants its subcontractors and its prime contractor to abide by. Uh, so, how do we actually draft these customer flow down terms? Essentially, you would look at the end customer contract, and you would see what kind of requirements need to be complied by the subcontractor. Because in case the subcontractor fails to comply with these obligations, the prime contractor would be responsible to the end customer, and this might also result in breach of its agreement. Examples of customer flow downs would include certain regulatory compliances, customer requirements, certain quality standards, insurance requirements, certain SLAs, requirements related to confidentiality, data protection, audit rights, termination rights, and transition assistance. It would also include certain policies that need to be complied by the subcontractor. It's always important that the subcontractor is explained the reason as to why certain provisions and obligations have been incorporated in its contract so that it understands what is expected out of it. I would say a subcontracting agreement needs to be viewed from three angles. That would be your deliverables, commercials, as well as the legal obligations. Once everything is balanced out and once there's clear expectations set, so it would ensure smooth running of the contract, and it would also ensure that we have every contractual protections in place for the prime contractor as well as for the end customer. I hope this list helps you to draft your subcontracts better. Thank you for having me here. And in case you have any doubts, you can always reach out to my legal for further clarifications. Thank you so much.